latest in litigation against Illinois' gun and magazine ban has, of course, a couple of different tracks we've been following. The Illinois Supreme Court denying State Representative Dan Caulkins' request that they vacate their decision against his challenge in the gun and magazine ban from back in August. So we'll touch on that. Also, we've got the latest out of the Southern District of Illinois, where we'll pull up the docket of the next steps, so to speak, of where we're at in that case, challenging the state's gun and magazine ban on various grounds. So let's get going here as I get into the site for the Southern District of Illinois. If you recall, we have, of course, state-level cases and federal-level cases. And the state-level cases have really, exhausted themselves, if you really think about it. And those state-level cases, more and more, not going anywhere, especially in a state like Illinois. So you've got those state-level cases that, again, Tom DeVore has a couple of challenges he's looking to try to get addressed. His state-level challenge that was vacated after Caulkins' challenge was vacated, ultimately leading to him appealing to have it reinstated, and that wasn't approved in the district court in Illinois. Then you get to the appeals court, so we'll watch what happens there, and whether or not he's going to take it all the way to the Illinois Supreme Court. So you've got the DeVore cases still out there. But again, you've got also the Dan Caulkins case, which is an interesting trajectory to watch as we've tracked that here with Bishop on Air. And if you recall, Caulkins, he actually took his challenge to the Macon County Court, where in that district county court, the judge ultimately said that the law was unconstitutional, and then the state skipped the appeals court and went right to the Illinois Supreme Court. The Illinois Supreme Court, there were questions about judicial integrity, because a couple of the justices, when they were running for the office in 2022, took six-figure donations from the leaders of the other branches of government in Illinois. Governor J.B. Pritzker giving $1 million each to two Supreme Court justice candidates. Also, you had six-figure donations from the House Speaker and a political fund that the Senate President maintained, helping out the judicial candidates. So those candidates then win, and they're in office, and different storyline as well about the Supreme Court maps that were approved after decades of not changing the maps. So that's another story in its own. But regardless, you had Caulkins attempt to try to get two of those justices to recuse themselves over questions of judicial ethics. While that failed to materialize, they denied that request. The entire Illinois Supreme Court denied that request, and then months later, after hearing the arguments in May and August, they decided to side with the state, not with Caulkins. And then Caulkins, months later, took it to the U.S. Supreme Court, where the U.S. Supreme Court put it into conference. And then earlier this year, the U.S. Supreme Court decided not to take the case, along with like 200 other cases they decided not to take, right? So then we heard that Caulkins was bringing it back to the Illinois Supreme Court, and when we chatted with him several weeks ago on that, here's what he had to say in regards to how he wants this case to move forward back to the Illinois Supreme Court.
For recusal, the defendants didn't object to it. They didn't in any way object to our request for recusal. So maybe they weren't against our request for recusal, and we're back because of the good work that you and some other reporters have done on the $7.3 million super PAC money that was spent in this race. And we're saying that the two judges, should have disclosed that fact. They should have disclosed that Senate President Harmon had put $700,000 into this super PAC, and that his attorney, who also was in the courtroom as defending the Senate President, was responsible for spending that $7.3 million. I think that should have carried more weight with the Supreme Court, and we contend that we didn't get a fair hearing.
So again, Caulkins, when I talked with him a couple of weeks ago, just dipping back into the archives a bit, asked him about whether or not this is an attempt to possibly get a ruling again from the Illinois Supreme Court and take it back to the U.S. Supreme Court.
Probably not. I think we understand the pressure that the U.S. Supreme Court's under in its terms, what it's dealing with. And I don't expect that we would have a different outcome. But this is an issue with our Illinois Supreme Court. We're raising the issue again, and hopefully anyone else that's bringing a case against the governor, against the state of Illinois, will use the same arguments. And hopefully, if they don't recuse themselves in this case, maybe enough pressure in other cases, maybe it'll help others as well.
So Caulkins, hoping that you can get some kind of outcome that would be beneficial to other people. But let's now flash forward over to the Illinois Supreme Court's website, where you can see, and if you follow along, just search Illinois Supreme Court and you'll find it. But if you get to the website, you'll see high-profile cases. You click there. And then there's a whole bunch of high-profile cases, including you've got, let's go to the Supreme Court, high-profile cases. From there, let's take a look. This is interesting. First off, we'll touch on this after we finish up with Caulkins, but there's a petition here for the Illinois Supreme Court to review the guilty verdict of Jussie Smollett. Remember up in Chicago, MAGA country, he was accused of faking a hate crime and ultimately was found guilty of that. So we'll take a look at that. But let's flash forward to the Caulkins case. All right, so here's the Caulkins case and the timeline of it. In March, filed an appeal from the state, and then you had the arguments that were made, but also in between then, you had the motion for recusal, and we talked ad nauseum about that. And even we asked Governor J.B. Pritzker why he, donated to these candidates. So had all that drama, of course, a controversy, and then you had the hearing after the justices denied recusing themselves. Then you had to go to the Illinois Supreme Court, where they sided with the state. And ultimately, you had an appeal to the U.S. Supreme Court, which was denied. Now you get to the petition that we just heard from Caulkins a couple of weeks ago, filing that for the judges to vacate their opinion. Well, earlier this week, the Supreme Court denied that petition. So let's take a look at just briefly here. Not much written. It just really is. The order entered, the petition by appellees to vacate the judgment is denied. Just one word, denied. So, what's next? Talking with Caulkins a couple of weeks ago, it was, kind of speculated that the Illinois Supreme Court wouldn't really do much. Well, what else can be done about judicial integrity, about judicial ethics? I think that's a big question here that's still unresolved in the state of Illinois. And Caulkins postulates about some things that he may be able to do, or that legislators may be able to do, if anything at all.
That's a great question. For the last 5 years that I've been there, we've argued for ethics reforms. I don't know how we're going to get it done, Greg. If the Democrats refuse to talk about ethics reform, that they limited the contributions to these judges, and then the governor breaks his own law, and you can talk about technicalities, $500,000. You can do it twice. You can use different funds and skirt the law or whatever. It's we have one party rule. We have a governor that's wanting to run for president, I'm sure, and willing to do whatever they can to bolster his image across the country. But we'll continue to push for ethics reform. We're going to continue to shine a light on the Supreme Court, and That's all. That's the best that I can do.
So clearly, still a lot of unanswered questions on how to maybe shed more light on this. Is there any legislative action that can be taken beyond what has already been taken in trying to curb campaign contributions of the sort? So clearly, the Illinois Supreme Court, with the steps they've taken, have essentially at this moment, pending whatever happens with divorce cases, at this moment, looks like not much action is going to happen in the state court. But in federal court, you had the hearing last week with Judge Stephen McGlynn in the Southern District of Illinois, where he essentially told the lawyers again, we're not delaying this case on the merits. And this is after all of the back and forth that the Southern District had with this particular challenge of the gun and magazine ban. So if you recall, this case, just to give you the background for those tuning in here for the first time, it's Bishop on there. Hope you join me each and every weekday morning. Check out the clips, like, subscribe, hit that notification bell, follow me on X and Facebook and all that. Okay. But the Southern District cases, 4 different cases lumped together. You had Judge Stephen McGlynn hear that, while you also had Northern District, some cases separately being heard by different judges in the Northern District. In the Northern District, those judges on preliminary actions said the state's likely to succeed. In the Southern District, Judge McGlynn said that the plaintiffs were likely to succeed and put a temporary restraining order, or essentially a preliminary injunction, on the law, and that blocked the law from being implemented for 6 days, while the state appealed to the 7th Circuit, and the 7th Circuit also had appeals from the Northern District, so the 7th Circuit consolidated all those, put a stay on the Southern District's injunction, saying that the law was back in play. So only 6 days of an injunction in place before the appeals court said it's back in play. So there were several attempts to try to get that to the U.S. Supreme Court. You had the Beavis case out of Naperville, try to get to the U.S. Supreme Court. But while the 7th Circuit said they were on a rocket docket, the Supreme Court did not take up Beavis's appeal. And then the appeals court hears the case. They talk about military guns and stuff. And then all of a sudden you get into a ruling. I believe it was in November, ultimately siding with the state on the preliminary issues, not on the merits. So now that the preliminary issues have been exhausted, you've got the Southern District with Judge McGlynn moving forward with the case. And on Friday, that status conference had them essentially spell out where they're at in getting the case moving forward. Let's take a look at the dockets, because Tuesday they were supposed to turn in the names of those who were going to be essentially handling this for the plaintiffs. And indeed, yesterday you had a motion to appear pro hoc vice by attorney Mariel Brookins on behalf of Caleb Barnett and other plaintiffs, Brian Norman, and pro gun and indoor range. So at least one of them and several others here earlier this week, you had another pro hoc vice in filing the fees and such. So that's going to be moving forward. We'll watch and see what the latest updates are on that case. But also interesting, if you follow some of the other individuals involved in this type of litigation, Hannah Hill, she's with the National Foundation for Gun Rights, and she posted yesterday that we just filed to dismiss our lawsuit over Highland Park, Illinois' semi-auto ban. Don't worry, this is not bad news, she said. We started out with 2 lawsuits against individual cities in Illinois, then Illinois passed a statewide semi-auto ban, and we moved in both of our lawsuits to include the state ban. We succeeded with only one of those lawsuits, Beavis v. Naperville. As a result, Beavis took off, while Goldman versus Highland Park sat on ice. Same issues under consideration, so there was no point in the district court ruling while Beavis was pending in the 7th Circuit. Once the 7th Circuit ruled against the 2A in Beavis, Highland Park judge applied that precedent and upheld the Highland Park assault weapons ban. Much more faithful than most courts are willing to apply Supreme Court of the United States precedent, unfortunately. Rather than appeal Goldman to the 7th Circuit, which just ruled in favor of the statewide ban, we decided to drop Goldman for now and focus on Beavis. If, as we hope and anticipate, SCOTUS overturns the Illinois statewide ban, that will apply to Highland Park's local ban as well. Once we get a nationwide ruling turning assault weapons ban, overturning those, then we can always come back to make sure that Highland Park complies. But for now, the goal is to save our members from the unnecessary cost of duplicative litigation and legislation. Well, I think it may be litigation. Speaking of Beavis, stay tuned. We hope to make an announcement soon. And that announcement in the Beavis case expected to be that they're going to reapply to the U.S. Supreme Court to intervene. But again, the Beavis case separate from the Barnett case in the Southern District. All right, so the Beavis case up in the Northern District courts, the Barnett case consolidated in the Southern District courts. So we'll be tracking all of that. All right, so that's some of the latest litigation back and forth with the gun and magazine ban. And I wanted to just touch on this briefly. Back to the Illinois Supreme Court, Jussie Smollett motioning an appeal to the Illinois Supreme Court, and take a look at just some of this here. Prayer for leave of appeal. Jussie Smollett respectfully petitions this court to exercise its judicial discretion and review a question with the potential for wide-reaching implications within this state, granting him leave to appeal the December 1st, 2023 decision of the Illinois Appellate Court, 1st District. The petition is brought under the authority of the Supreme Court rules. And then it goes through some of the statement of jurisdiction and even more. But you can read this 93-page ruling or this 93-page filing yourself. And I'll just leave that there for you guys to deal with. All right, it is Bishop on Air. Like, subscribe, hit that notification bell, and join us each and every weekday morning as we do this and keep you guys updated on what the latest is here in Illinois when it comes to the litigation against the state's gun and magazine ban. All right, we'll be back with more. As always, Bishop on Air, everywhere